Okay. Uh, Good evening, everybody. So, the topic for tonight is American Jews and the First Amendment. And I assume that the First Amendment is something that we all support. But specifically, I mean, once we get to it, I mean, you all know me, right? We can't just dive in. You got to do a little bit of history and a little bit of analysis first. But I want to look at how this plays out, at least in my opinion, in some of the discussion over abortion rights in this country. So just as a reminder, I'm going to read to you the text of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Okay, so as far as, so we want to look really at the first part of it, that is the stuff dealing with religion. And it's important to remember that there are two different clauses here. There's the Establishment Clause and there's the Free Exercise Clause, right? So the Establishment Clause means we can't have an official state religion. And the Free Exercise Clause means that the federal, really originally the federal government, could not prevent you from practicing your religion. And originally, like all of the guarantees of the Constitution, this was held to apply only to the federal government, and it was only extended to the states by the 14th Amendment after the Civil War. And prior to that point, states could have an established church and they could restrict freedom of religion. For example, in Connecticut, where I moved here from, the Congregationalist Church was the established church of Connecticut for a good long time after the adoption of the Bill of Rights. And Maryland was, I found out in doing a bit of research, Maryland was among the last U.S. states to remove the prohibition on Jews holding public office. 1826, the Maryland that's not its official name, but it was known as the Jew Bill, was passed in 1826. And prior to that, you could only take public office upon swearing, making a declaration of a belief in the Christian religion. And in 1826, Jews could run for and be sworn into public office, provided that they swore to a belief in a future state of reward and punishment. And the fight to pass it was led by Jacob L. Cohen Jr. and Solomon Etting. And I actually knew about Solomon Etting before, because Solomon Etting, believe it or not, was born in York, Pennsylvania, where I was the rabbi from 1997 to 2001. And his family moved from York to Baltimore, and he became a merchant and a lawyer and wanted to get involved in politics. And anyway, Cohen and Etting, after the passage of the Jew Bill, both ran and were elected to Baltimore City Council and became the first Jews to hold elected office in Maryland. So, as I said before, there's the Free Exercise Clause and the Establishment Clause, and sometimes you find them in at least I think you do, in a bit of tension, right? Now, so the Free Exercise Clause says the government cannot prevent you from exercising your religion. Question is the free exercise clause absolute, right? And I think, clearly we would have to say it's not absolute, right? I mean, after all, the Torah tells us that if a man has a stubborn and rebellious son who is a glutton and a drunkard, then that man should take his son to the elders of the city, to the gate, and say, "This our son is a glutton and a drunkard. He does not listen to our voice," and they should stone him to death. Okay, and I would dare to venture that, should you have a smart ass teenage son and you put him to, and you kill him and you are arrested for his murder, and you say, hey, free exercise clause, right? I mean, the Torah tells me that I should do this. I'm not a lawyer, nor do I play one on TV, but I don't think that that attempted defense would go very far. Alan, Joe, what do you think?
Well, I think it would work because what you would probably be doing would be to have that you're not competent mentally to do something like that, and this may be proof of it.
Well, perhaps, okay, but so the free exercise clause only really goes so far. However, I mean, in the 20s and 30s, we had prohibition in this country, and both the Catholic Church and synagogues were able to apply to the government for sacramental wine permits. For the Catholic Church, this was relatively straightforward because the requirement to use wine is for Mass, which takes place in the church, and the sacramental wine permits were given to priests. But in Judaism, the use of wine is not only in the shul, it's at home for Kiddush and for Seder. And so rabbis could get sacramental wine permits. And it may surprise you to know that this was both very lucrative and subject to abuse, and was a good side business for a lot of rabbis. To the point where the Rabbinical Assembly actually ruled correctly, in my opinion, that you don't need to use wine, you can use grape juice instead. Now, this is halachically what we call machloket. It's a matter of dispute. I mean, I hold that way. I'm not much of a wine drinker. And red wine in particular hits me very strongly. So I always make Kiddush on grape juice, not on wine. But there were exemptions to prohibition for the use of wine in religious rituals. And so that was obviously the sacramental wine permits ended when prohibition ended, which is, I think, 1933. So sort of like key, if you look at First Amendment jurisprudence, religious freedom jurisprudence, you will come across the term the lemon test quite frequently. And this has nothing to do with citrus fruits. There was a case decided by the Supreme Court in 1971 called Lemon v. Kurtzman. And the question that the case dealt with was whether states could fund teaching of secular subjects in private religious schools, right? I mean, like, you know, nobody really disagrees that for the Charles E. Smith Jewish Day School, that the state of Maryland cannot give money to hire the Bible teacher or the Talmud teacher or whatever, right? But could the state give them money to hire a Spanish teacher, a math teacher, a biology teacher, right? And there were states that were doing this. And it got to the Supreme Court, and the Supreme Court ruled that actually states could not do this, that this was a violation of the First Amendment. And they came up with a three-pronged test to determine if a law is or practice is constitutional, or actually if it's unconstitutional. It's unconstitutional if it lacks any secular purpose. That is, if the practice lacks any non-religious practice, right? And second, the practice either promotes or inhibits religion. And third, the practice excessively, in the court's opinion, involves government with a religion. Okay, so, and it's got to meet all three, right? So it seems to me, without, and I haven't read the whole case file and whatever, I mean, does paying the math teacher in a Jewish day school serve a secular purpose? Yeah. I mean, right, right, we want a society of math literate people, right? Does it promote religion? Yeah, it does, right? That's where, in my opinion, it fails this test. It promotes religion by making day schools cheaper, right? And therefore, I mean, the only reason that you send somebody to a day school is a religious reason. So by paying secular subject teachers in religious schools, you're promoting religion. Does it excessively involve the government with religion? Probably not. But I think it fails on the second prong of the Lemon test. Okay, the next big case was Employment Division v. Smith, 1990. And this was a case of two Native Americans who, ironically enough, in my opinion, were employed by the state of Oregon as drug rehabilitation counselors. And they were arrested for using peyote in Native American religious ceremonies and were fired from their job. Now, it is a fact that certain Native American religions use peyote as a sacrament. I mean, no different, from that perspective, no different than us using wine for Kiddush, and even having done so during Prohibition. So they were fired, and essentially the Supreme Court ruled that they were fired for violating a generally applicable law. Right? It wasn't a law that was aimed at Native Americans. It wasn't a law that was aimed at peyote or aimed at drug counselors. It was a generally applicable law prohibiting the use of peyote, and that you could not essentially in a broad swath, you could not claim exemption to generally applicable laws under the color of religion. And that's what Employment Division v. Smith held. But there was a subsequent case in 1990. Well, it was argued in 92. It was decided in 93, called the Church of Lukumi Babalu Aye versus Hialeah. Okay, where you had a Santeria church. Santeria is an Afro-Caribbean religion, and there was a Santeria church in Hialeah, and they practice animal sacrifice. The animal's carotid arteries are cut, and the animal is eaten. Okay, now if this sounds familiar, I mean, it's something that we no longer do, but right, this is the Korban Pesach. This is the Paschal sacrifice, right? You slit the animal's throat, you slit the animal's carotid artery, and you eat the animal as a religious ritual. And shortly after this church was established in Hialeah, the city council adopted several ordinances addressing religious sacrifice, and the ordinances prohibited possession of animals for sacrifice or slaughter, with specific exemptions for state licensed activities. Okay, meaning, if you could slaughter animals in a slaughterhouse, for commercial sale, but not as a religious ritual. And the Supreme Court ruled that this violated the free exercise clause of the First Amendment, because they were not neutral and they were not generally applicable, right? The ordinances had to be justified by compelling governmental interest, and they had to be narrowly tailored to that interest, right? And what is the compelling governmental interest in this case? There is none. I mean, the compelling governmental interest in this case is, yuck, we don't like Santeria, right? That animal sacrifice sounds icky, right? If they were to have, passed a law banning all animal slaughter in the city of Hialeah, arguably that would have met constitutional muster, right? But to ban slaughter in a religious context, but not in a secular context, that is clearly aimed at suppressing this particular religious context, and it targeted religious behavior and therefore failed to survive the rigors of strict scrutiny, right? And then now I find it interesting what personally, and I mean, I was in my early 30s back then. I guess I wasn't following this stuff so much, but what changed between 1990 and 1993? I mean, other than the facts of the case are different, because this really is not a generally applicable law. It was, quite clearly aimed specifically at suppressing a particular religious practice. But in 1993, Congress passed and President Clinton signed a bill known as the Religious Freedom Restoration Act, RFRA, which essentially reversed Employment Division versus Smith. RFRA prohibits any agency, department, or official of the United States or any state from substantially burdening a person's exercise of religion, even if the burden results from a rule of general applicability, except that the government may burden a person's exercise of religion only if it demonstrates that application of the burden to the person, one, furthers a compelling governmental interest, and two, is the least restrictive means of furthering that compelling governmental interest. Okay, so I take it that this is what's known as strict scrutiny, right? I mean, in other words, if you're going to pass a law that burdens my practice of religion, it's got to fulfill a significant government interest, right? And B, it has to be the least restrictive way of doing so, right? If you could serve that governmental interest in another way that was less restrictive, you would have to do that. And otherwise the legislation fails as a violation of the First Amendment. Okay, so bearing in mind RFRA, I now want to, and this is purely my own work here, looking at the question of abortion in light of RFRA. And again, I'm not a lawyer, nor do I play one on TV, but rabbis learn to read texts and apply them to novel situations just as lawyers do. I think that the methodology is not different. It's just that the body of text is different. And so, but I'm happy to have Alan and Joe who can correct my errors, should there be any. But okay, so first of all, it is not a burden on free exercise to ban something that your religion allows, right? In other words, the argument is made, Judaism allows abortion. Yes, Judaism allows abortion, right? That in and of itself does not make an abortion ban a violation of the First Amendment, right? It is not, it's not a burden for secular law to ban something that your religion allows. As an example, there are certain circumstances under which halakha allows a man to have more than one wife. First of all, if you're Sephardic, that's it. If you're Sephardic, according to halakha, you can have more than one wife. If you're Ashkenazic, there are still certain circumstances where, for example, your wife disappears, right? Your wife disappears, so you can't give her a get. You can't divorce her because she's disappeared. And there's no such thing as being declared legally dead in Judaism, all right? Or your wife, God forbid, goes insane and she is in an insane asylum and therefore does not have the mental competency to accept again, right? There's a device called Heter Mea Rabbanim, the permission of 100 rabbis that will allow a man to take a second wife, right? As far as I know, there is nowhere in the United States that that polygamy is legal. And you can't go to court and say, hey, I'm Sephardic, my religion allows me to have a second wife, therefore it is a violation of my First Amendment rights to not allow me to have a second wife. That argument doesn't wash, right? I mean, the state is not required to permit everything that your religion permits. Now, let's look at another thing. if the government were to ban animal slaughter and consumption of meat, right, is that a burden on the First Amendment rights of Jews? What do you think? Right? I mean, we have to eat kosher meat, we have to slaughter in a kosher way.
Nothing says that you must eat kosher meat. You can just be vegetarian.
Bingo. That isn't that's the way I read it, right? In other words, the halacha doesn't say you have to eat kosher meat.
Right.
It says if you eat meat, it has to be kosher,
Kosher.
right? Doesn't say, right, if you eat. I mean, I get this sometimes from people who say, I've got high blood pressure. My doctor says I can't eat kosher meat anymore because it's soaked and salted. So now I can eat treif meat, right? And the answer is no, you can't. You just don't eat meat, right? I mean, there's no right. I mean, the fact that you're not allowed to eat kosher meat doesn't give you the right to eat treif meat. You just don't eat meat at all. However, if a locality were to ban all slaughter, I think you would have to be you lived in that locality, you'd have to be a vegetarian. However, if they banned kosher slaughter but not other types of slaughter, that would presumably be a First Amendment violation, and courts would strike it down, right? Because that is aimed at a particular religious practice. And usually, I mean, this is one of the things that often brings Jews and Muslims together, because kosher slaughter and the only difference between kosher slaughter and halal slaughter is the identity of the slaughterer. I mean, other than that, kosher and halal slaughter are exactly the same. And if a Muslim cannot get halal meat, they're allowed to eat kosher meat. Now that's a door that doesn't open in both ways, right? We are not allowed to eat halal meat, but they are allowed to eat kosher meat, right? But if a government were to ban kosher slaughter, but not other types of slaughter, it would have to show that it furthers a compelling governmental interest and is the least restrictive method of doing so, and therefore would probably fail, right? Because what is the compelling government interest that would have you ban kosher and halal slaughter, but not any other type of slaughter? But there are localities that have banned hoisting and shackling, which actually many kashrut agencies also now ban it. The idea is that the hoisting and shackling makes it for a cleaner cut and it's easier to drain the blood, but it's cruel. I mean, it's painful. It's painful to the animal. And some have tried to mandate pre-slaughter stunning, right? That you can't slaughter a live animal, you have to stun the animal first. And most halakhic authorities hold that invalidates the slaughter. That if an animal is stunned before slaughter, it's not kosher. I mean, some of you may have seen this movie a few years ago, the Temple Grandin story. Temple Grandin is like the leading scientist who designs humane slaughter pens and so on and so forth. And she goes all over the world. She's not Jewish. She's severely autistic. And she actually, she says that severely autistic people see the world the same way that animals do. And having had a couple of dogs, I think that there is some some validity to that claim. But anyway, but I'm going far afield at this point. Now, if the government were to ban circumcision, that would be a burden on free exercise, right? Because Judaism requires circumcision, right? Now, I could imagine that such a law might be held to be constitutional because the claim would be it furthers a compelling governmental interest, right? I mean, you know, and the fact of the matter is, right? I mean, my parents didn't ask me when I was 8 days old if I wanted to be circumcised or not, right? They violated my autonomy, right? And so protecting somebody's future autonomy or preventing pain or whatever, you could make, whether you would win or not, I don't know, but you could make the argument that I think you could probably construct an argument for a compelling governmental interest that would allow banning circumcision, in which case, what should a Jew do, right? And the answer is, if it were upheld by the courts, you can't follow that law. You can't. So either you have to go ahead and circumcise in violation of the law or move away. I mean, there was a referendum a few years ago in San Francisco, of course, San Francisco, to ban circumcision, right? It did not pass, but if it had passed, right, and been upheld by the courts, and you know, San Francisco then further said, you know, the way some states are trying to do, which is to say, you know, not only can't you get an abortion in Mississippi, but if you go from Mississippi to another state to get an abortion, we'll arrest you when you come back to Mississippi. If they were to pass a law like that vis-a-vis circumcision in San Francisco, you can't live in San Francisco. It's as simple as that. Because you cannot follow that law, period. You can't follow that law. You know, so would that ever happen? I don't know. I mean, look, it could. I mean, societal tides are changing. I don't think it's likely to happen in the lifetime of anybody participating in this conversation, but in our children's or grandchildren's lifetime, who knows? Now let's look at abortion, right? Judaism does not simply allow abortion. In some circumstances, it requires it, okay? And we're all familiar with the term pikuach nefesh, right? Which generally is translated as saving a life, but pikuach nefesh actually has a much broader definition, right? It is not just the physical saving of a life. Pikuach nefesh also means prevention of extreme mental anguish, okay? And why is that? Because, among other things, the word nefesh, right? I mean, the Hebrew word nefesh means soul, right? And you know, we talk about, you know, the boat went down with 30 souls on board. I mean, it's not common in English, but it's not unknown either, right? But interestingly, somebody who's mentally ill, in Hebrew, that is known as chole nefesh, right? Their soul is ill. Right, so that saving a person's nefesh is not only their life, and mental anguish, severe mental anguish, comes under the rubric of pikuach nefesh, which therefore does not merely allow abortion, but under certain circumstances would actually require abortion, right? And last year when we looked at abortion in halakha, We saw a case where Rabbi Eliezer Waldenberg, who was, an ultra-Orthodox medical halachic decisor in Israel, allowed, and you have to understand that in that context, when we say allowed, we essentially mean required, right? Once you go to a rabbi, the rabbi is either going to forbid it or require it, right? I mean, they're rarely going to say, well, you can if you want to, right? And so the case presented to Rabbi Waldenberg was a woman cheated on her husband, okay? She got pregnant from her lover. All right, she has since repented and gone back to her husband, and now she wants to have an abortion because bearing her ex-lover's child will remind her constantly of her sin, right? This little kid conceived in adultery will be running around her house 24/7, and it will remind her of her sin, and she can't bear that, okay? And Rabbi Waldenberg allowed her to have an abortion because of that, okay? So, that's a pretty, in that context, it's a pretty liberal ruling, okay? So that halakha doesn't merely permit abortion, right? There are circumstances under which it would require abortion. Okay, so now, if Roe v. Wade is overturned, that does not, in and of itself, ban a single abortion, right? It returns it to the states, right? However, anticipating the overturn of Roe v. Wade, red states are running to pass a flurry of abortion bans of various types, right? And it's hard to sort of generalize because, different states are passing different laws. And as far as I know, most of them contain a life of the mother exemption, right? Because it would be politically untenable, frankly, right? Some of them contain a rape and incest exemption. Many do not. Okay, and I'm unaware of any that contain a severe mental anguish exemption. And if you did have a severe mental anguish exemption, one of the things that worries me, not specifically as a Jew, but just as an American civil libertarian, is, how do you create this framework of seeking permission? From who? And how does that work? Right? And if we were to have a severe mental anguish exemption, how does that work? Who do you go to? Do you have to go to your clergy person? If you have to go to your clergy person, that violates the Establishment Clause, right? And if you don't allow it, to my mind, it violates the Free Exercise Clause, right?
Right.
If carrying the fetus to term would cause extreme mental anguish, many rabbis would say that Judaism requires an abortion. Others might not, but then this gets us into the excessive entanglement clause, right? Courts cannot decide that one rabbi has got it right and another rabbi has got it wrong. So banning an abortion that the pregnant woman's rabbi requires, right, is a burden on free exercise, right? Courts cannot inquire into the correctness of a belief. They can only inquire into the sincerity of a belief, right? And that's where, in other words, you see cases like this sometimes where and they're always tragic, where you have a situation like let's say a Jewish man and a non-Jewish woman get married, and they make an agreement that the kids will be raised as Jews, right? And then they divorce, and they have split custody. And on the weekends that the mother has them, she's sending them to catechism and bringing them to church. And then the rabbi says, you're violating the agreement that we made, right? And then the woman's lawyer calls an Orthodox rabbi who says, the kids aren't Jewish. The kids aren't Jewish, right? Because Judaism says, they're only born Jewish if the mother is, and the mother's not Jewish. They never converted, or they did convert. It wasn't about whatever. And then they then the father brings in a Reform rabbi and says the kids are Jewish. At that point, the court says, we can't decide this anymore. We could maybe decide whether you have violated an agreement that you've made, right? On the basis of contract law. We're not going to decide whether these kids are Jewish or not, because you have one rabbi who says they are, another rabbi who says they aren't. We are not in the position to decide which rabbi is right and which rabbi is wrong. That's just not what courts do, right? If we can decide it on basis of secular contract law, then for sure, but not the moment we're put in a position of deciding which of two rabbinic opinions is correct, that's excessive entanglement. Okay, so now here's where we get into something that I see as sort of circular. Okay, an abortion ban would be okay if it furthered a compelling governmental interest and was the least burdensome way of doing so, right? What compelling government interest does banning abortion serve?
Promoting life.
Promoting life, right?
Promoting life. Right.
Promoting life.
Right.
That is to say, saving the life
Saving.
of the fetus, right? But in order to do that, right, you have to decide that the fetus is indeed a human being, right, whose life is worth protecting, right? Well, guess what? Father O'Flaherty says that fetus is a human being. Rabbi Arian says it's not. Right? What gives the legislature or the court the right to decide that Father O'Flaherty is correct and Rabbi Arian is not correct? Right? I mean, to me, that is a violation of the Establishment Clause, right? Declaring that a fetus is a human being and that therefore the state has a compelling interest in preserving the life of that fetal human being is a violation of the Establishment Clause, right? I mean, and to me, now, having said that, right, I mean, the Constitution is whatever the Supreme Court says it is, right? And unfortunately, I have no faith. I have no faith in the current Supreme Court majority, right? I mean, if they have no problem lying in senator's office and they have no problem lying in the Judiciary Committee, they have no problem favoring Catholicism over Judaism as the state religion, right? But if we had, an honest Supreme Court, I don't see how a complete abortion ban fails the Establishment Clause. I just don't see it. But like I said, unfortunately, I don't have any faith in the current Supreme Court, and that's where we find ourselves. But that's why, and I'm not. I mean, I don't believe I'm an alarmist. I really don't. But and it's not so much overturning Roe v. Wade, which simply opens the door. But if that door is walked through, it essentially declares Judaism and liberal Protestantism second-class religions in those states that pass complete abortion bans. It does, and now fortunately, as much as you have certain states running to ban abortion, you have other states running to preserve abortion rights. And and this is what happened pre-Roe v. Wade, is that clergy who supported abortion rights. I mean, there was an underground railroad of sorts, right? And that's what we'll have. I mean, we'll have an underground railroad, and all of you, with the exception of Marcia, because I mean, Illinois will actually probably a bigger role than Maryland, because Illinois is adjacent to some of these states in ways that Maryland really isn't, except maybe West Virginia. But you'll be able to sign up to host women who come to Maryland for abortions, and you'll be able to make donations to my discretionary fund to help pay for them, and so on and so forth, because I think it will absolutely be a mitzvah to help fund abortions. And then, if states are really serious about prosecuting people who go out of state for abortion, and I don't know where that leads, but and that is probably like I'm at that point getting out of my lane. But in terms of the status of Jews and Judaism in this country, an abortion ban is really, really problematic, because it officially, I think, in my opinion, declares Judaism a second class religion, and to me, that's obviously deeply problematic. So I'm gonna stop here. I would really welcome response to my sort of legal analysis, whether that seems to hold water, and then wherever else we want to go for a few minutes.
So Rabbi, would a state ban that had an exception for the life of the mother be halakhically acceptable then? Or because
a life of the mother would not go far enough, because it would have to have
mental anguish.
It would have to have a mental anguish exemption too.
Anguish. Mm-hmm.
And then that, like I said, that to me, that's unworkable, but it's not necessarily contrary to halacha, right? I mean,
right.
I still think, like I say, as an American, I still find that problematic. But if I'm, analyzing it halakhically, it probably is okay. Yeah, Alan.
Rabbi, you did very well to give us the background, and I appreciate your thoughts today. However, I don't know. I have skimmed the leaked opinion. I have skimmed it.
Right.
Of course, I've seen the headlines. I don't know what was argued. I'm assuming that the issue is whether the state has the right to do this.
Right.
It doesn't mean that any one person can't object to it based on a religious issue. And I suspect, and I don't know, that there was not an argument made saying, well, this really discriminates against Hebraic thinking and against liberal Protestant thinking. There probably were amicus briefs at the
For sure there were.
Of the Supreme Court, such that they made a difference. But I think the real nub of it is whether the state has the right to do this. And these things get very narrow. But, and the question I've sort of been thinking of, So let's say there's a female and she's pregnant and she wants to stop that pregnancy and she's in Texas, Mississippi, or wherever else. First off, you have to do everything on an expedited basis. Most pregnancies only last for 9 months when they're going full term. And so you have to move very quickly. It's very expensive to go through the process. As a practical matter, she'd want to go somewhere else and have this abortion. But I don't know, and Joe, maybe you have some thoughts. I don't know who has standing up front if they're not pregnant to argue, to challenge this. And in a really conservative state, I think they'd sort of require that. But I think that the points you raise are very good. And I think at some point, they could be the basis for modifying some of these rules.
No, like, of course, like standing is a big problem. I mean, that's why that was the problem with the Texas, with the, why the Supreme Court let the Texas law go into effect prior to the leak of this opinion, because nobody had standing to challenge it. All right. On that cheerful note, any other thoughts? Any other thoughts or questions? Yeah.
Well,
All right.
I'm still waiting for the IRS or any other state revenue agency to say that a fetus is something that's deductible. Because all the tax codes say you cannot deduct a child until it's born alive.
Right. No, look, I mean, I think you can poke a lot of holes in it. I mean, frankly, those states that are going to have a rape or incest exemption, right? I mean, the rape or incest exemption is probably because it's politically untenable not to have it, right? But if you sincerely believe that a fetus is a human being and therefore abortion is murder, so it's okay to murder people because they were conceived via incest or rape, right? I mean, nobody would say that, right? I mean, I murder my next door neighbor and I'm arrested, and when I'm brought to trial, I say, hey, I can prove that my next door neighbor was conceived in an act of rape, and therefore I'm acquitted, right? If you really support a rape and incest exemption on other than pragmatic grounds, you don't really believe that abortion is murder. It seems to me, right? I mean, I just, frankly, the level of hypocrisy around this issue, I mean, I don't know. By now I've lived 62 years on this planet. Hypocrisy should cease to shock me, but sometimes it still does. I don't know what to tell you. We're supposed to give, like Nehemta, we're supposed to give some comfort, some consolation at the end, but I find myself, more and more, whether it's the Supreme Court or whether it's, mass shootings or whatever, searching for consolation these days is really,
Rabbi, one more question.
Yeah.
One more question. You've talked about how some Orthodox rabbis are cozying up to the evangelical movement on this issue.
Yeah.
If there were to be total state ban, how do you think those rabbis would react? What would the argument be for justifying them?
I have read a couple of articles on that where basically, look, they acknowledge that a complete ban on abortion is a violation of halakha. Okay, they acknowledge that they can only walk 90% with the evangelicals and not 100%. Okay. However, they say not to worry. Not to worry. Either states will allow exemptions, or, and this is, to me, is a really like morally bankrupt argument. There are few enough such problem pregnancies among Jewish women, and there are enough wealthy Jews that we will find a way to obtain required abortion for Jewish women who need them. We'll pay for them to fly elsewhere. We'll pay for their abortion, et cetera, et cetera. But, you know, frankly, if your moral universe extends only to your fellow Jews, you're not reading the same Torah that
And the
I'm.
ones who are, right, and only the wealthy ones, right?
Well, no, what they're saying
Well,
is that if there's a poor Jew who needs an abortion,
right,
we'll collect tzedakah and we'll pay for her to get the abortion. We'll pay for her to fly, da 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 da. But and they're sincere. I mean, the one thing I have to say that, like, for example, when my mom was in the hospital for months, right? Go to any hospital in the New York area. There's a B Corps holy room, which is funded by Satmar, okay? And you go in there and every kosher food you could possibly want, right? And then the rabbi comes in and says, take home, take home, take home. I mean, they are very, very, very charitable towards other Jews. But the problem is the concern stops there. And we live in a society. We don't live just in a ghetto. And that's the problem. That's the problem. So I think that they're sincere, but well, we'll take care of Jewish women who need abortions doesn't really resolve this societal problem. All right. Good night, folks. Shabbat
Thank you.
shalom.
Good
good
night.
night, thank you.
Very interesting.
Thanks.
Very good. Bye.